Welcome back. We're talking about, now I call her Justice Sotomayor because the rubber stamp is coming down. I mean, it's a done deal. She is going to be sitting on the Supreme Court. Today, she said she accepts a ruling made by the Supreme Court last year that the individual's right to own a gun is guaranteed by the Second Amendment. But it isn't quite that simple. Joining me now to talk about the new justice and her views on the right to bear arms is Wayne LaPierre. He's the Executive Vice President and CEO of the National Rifle Association of America. He conducts the affairs of an organization with more than 3.5 million members. Wayne, great to have you back with us here on the Lou Dobbs Show.
It's good to be with you, Lou.
Have you been glued to CNN this afternoon watching the Sotomayor?
I sure have. We've been working with Senate offices all day, back and forth, trying to pin her down, and we sure have.
I thought, and I just, before we go too far into it, I thought that the exchange between Senator Orrin Hatch and Justice Sotomayor, I thought was very revealing.
Yeah, I did too. I mean, and every law-abiding American gun owner and Second Amendment supporter should be very concerned about a Judge Sotomayor on the Supreme Court. I mean, in the past, she has ruled that the Second Amendment is not a fundamental core right.
Right.
I think a huge majority of American citizens disagree with her that. She has also ruled in the Maloney case that it's not an individual freedom that should apply to citizens all over the country. She seems to be saying, well, I'll accept the Supreme Court saying if you live in Washington, D.C. or on an Indian reservation, gosh, the Supreme Court has said it's an individual right there, but in terms of extending it to people in Texas or Wyoming or Kansas or anywhere else in the country, her view seems to be no.
What about her view that the Second Amendment, as you say, is not a fundamental right and not incorporated and doesn't apply to the states? She said it was based on precedents and that the holding that precedents did not apply to the states. Do you agree?
No, I'm astonished by her reply on that. One, she totally disregarded the precedent of the recent Supreme Court Heller case,
right,
where the Heller case specifically instructed lower courts, including hers, if you get a Second Amendment case, we want you to apply modern 20th century incorporation law. And as Senator Hatch was saying during the hearings, that means due process and equal protection,
right,
and that means the Second Amendment should be extended to the states. And what that means
through the 14th Amendment.
Through the 14th Amendment, which means if you live in Kansas or Texas or anywhere else in the country, you have an individual right to own a gun. She completely disregarded the precedent of the Heller case,
right,
and instead stood there and told the senators, well, I decided that case based on the precedent from the 1800s, which is exactly what the Supreme Court in the Heller case told her not to decide cases on.
Yeah, it's fascinating to watch this. In most instances, I would say that this has been once over lightly, this hearing. The examination, I just, what do you think as you watch it? I have seen nothing but, frankly, political theater. Yesterday, under the Ginsburg rule, it was just a waste of time listening to 20 senators blather on for 10 minutes each, 200 minutes. She speaks for less than 8 minutes. We don't know anything. She's not saying anything today. It's all chuckles and giggles. I don't see the point of this.
It's all the inside the beltway stuff. And let me tell you, the NRA is headed toward coming out and opposing her nomination in the strongest terms. I mean, the historical argument for incorporating the Second Amendment through the 14th to apply to every American citizen is stronger than any of the others. I mean, it not only has a textual context with the words of the Second Amendment, but the crystal clear intent of a co-equal branch of government, Congress. I mean, after the Civil War, when they were passing the black codes saying that freed slaves couldn't travel or get educated or speak or own a gun to protect themselves from the Klan, Congress stepped in and not only passed the 14th Amendment, but passed the Freedmen's Act specifically saying that freed slaves had an individual right to own a firearm under the Constitution of the United States, an individual right of all American citizens. And she completely is disregarding that and has put her head in the sand. I mean, and we're headed toward opposing her. And I hope we can convince a bunch of senators to join with us.
Well, Wayne, as we've watched her walk back from, as I love the Washington parlance, walked back from her positions, she's reversed herself, recanted her position, saying that a wise Latina woman could make better judgments than a white male judge. She's reversed herself on the statement at Duke University Law Forum 4 years ago, in which she said that appellate court judges make law. Now she says they simply apply it. How much of this do you take as sincere?
Well, I don't know. I mean, it's a lot of inside the Beltway posturing, and I mean, we all know what's going on there. But I mean, I'm a practical guy in terms of how all this affects the average citizen in this country that believes they have the freedom to own a firearm under the Constitution, the Bill of Rights, and this is real for us. I mean, this Chicago case, which is the NRA case, is going to end up before the Supreme Court. And believe me, I want a majority of pro-Second Amendment judges on there that are going to say that the Second Amendment not only applies to Indian reservations and the citizens of Washington, D.C., as Sotomayor apparently believes, but it applies to every individual American citizen regardless of where you live. Because when a criminal breaks down your door at 2 a.m. in the morning and comes at some homeowner, Justice Sotomayor is not going to be there, and we better make sure every American has that constitutional guarantee to own a firearm and to be able to protect themselves in terms of self-defense against the bad guys. And, Lou, what bothers me is the American public instinctively understands that. They understand this is their freedom. They understand it like food will quench their hunger, water will quench their thirst, that if they have a firearm, they can protect themselves from the bad guys, and it's their freedom, it's their right. And if Judge Sotomayor does not understand that, in my opinion, she shouldn't be serving on the Supreme Court, because Americans instinctively get it.
Yeah, we get it. We also get when we're being gamed in all of the legal artifice about whether this derives the Second Amendment derives through incorporation through the 14th Amendment, or she has to go back to precedent that she found in the late 1900s to subvert that reasoning. I mean, this is treacherous stuff. I mean, that she's playing with, and she's doing it right out in the open, rather boldly.
Yeah, and I don't know why the senators are not being more, and we're urging them to be more forceful on calling her on this, or. I mean, it's very crystal clear when you read the Heller case. They said individual right, and they also gave all lower courts a roadmap for deciding future cases on the Second Amendment, which was to apply the 20th century incorporation law. Right. And she did not do that in Maloney. She said that it's not an individual freedom unless you're on an Indian reservation or you're in Washington, D.C.
Insane.
And it's just it's crazy. And
yeah.
And then recently, just an hour or so ago, in questioning by Senator Kyle from Arizona, because this issue is going to end up in front of the Supreme Court, she said that she is not going to recuse herself from reviewing her own opinion. I mean, so if this whole issue of incorporation, which she decided the wrong way in the lower court and just thumbed her nose at the Supreme Court ruling, she said when she gets on the Supreme Court, she's going to decide her own case and not necessarily recuse herself if this issue comes before the court.
Well, that's kind of funny, because when she was, the irony is that when she was talking with Senator Hatch, she had to say that on one of her rulings she couldn't remember what the case was based on.
And that was only from a couple months ago.
Right.
So,
right.
I mean, you know, and I know a lot of people, of your listeners out there, are big Second Amendment supporters, and, you know, we all fear what's around the corner. I mean, we know. We listen to the Feinsteins, the Schumers. We know where a lot of the national media is. We know President Obama's record prior to announcing for president. And I don't want anyone on the Supreme Court that's not strongly pro-Second Amendment. I mean, I'm a Second Amendment absolutist, and I can just promise people NRA is going to stand unflinchingly for the Second Amendment, and we are headed in the strongest terms to oppose this nomination.
All right. Well, Wayne, we appreciate it. You can put me down as being in support of each and every one of those amendments in the Constitution. Isn't it funny that we would have folks who could define themselves as not supporting elements of the Constitution of the United States of America?
Yeah, judges can't pick and choose whether they like the first or the third or the second or the fourth. I mean, the Bill of Rights is what makes our country different from every other country in the world.
Absolutely.
If people don't understand that, they shouldn't be on the Supreme Court.
That, by the way, and having the right to bear arms and make certain that we're not taken advantage of by any government that decides it will be tyrannical. I believe that's the basis of that freedom.
It's put there for freedom, and we still need to be free today, and you're not free unless you have a right to own a firearm.
Amen, brother. Wayne LaPierre, we thank you for being with us.
Thanks for having me, Lou.
Thanks. Wayne LaPierre, he is the CEO of the National Rifle Association.